Dear friends, welcome to the next topic of study in the ongoing course in Journalism and Mass Communication. This unit deals with the crucial issues of media ethics and law. In the previous discussion on this subject, we had talked about the broader themes of ethics in the media, the situations when questions related to media ethics generally rise and agitate the people's minds, and the role of various organs of society, namely the government, the corporate sector, and the media organizations themselves in upholding ethics. Now, we shall discuss the mechanisms available for providing relief and redress to those who have been aggrieved by the media. The first such institution that we shall take up is the Press Council of India. The press councils are the offshoots of the 20th century press. The councils were set up in Britain in 1953 on a voluntary basis and in India in 1966 by a statute with a view to checking press abuses. In Britain, the Press Council was replaced by the Press Complaints Commission, or the PCC, on 1st January 1991, and since then the PCC has been doing the job of self-regulating the press in the UK. In India, the Press Council of India was abolished in 1975 after the promulgation of internal emergency, but it was set up again in 1978 through another statute. However, in the global scenario, the first press council was established in Sweden in 1916 and the first press ombudsman was appointed in the USA. There might be some difference in the philosophy of the governments and in the general climate and traditions of freedom in these countries, but nevertheless their experience has value for the students of ethics in the media today. It also must be noted that from within the community of journalists there has been opposition to the idea of the press councils, but most believe that since journalism is a social activity and not a private activity, therefore a structured working of journalists and the media as such is imperative, and that demands some monitoring as well. Journalists at times are careless about the impact on the public of what they are writing. Sometimes they publish incorrect stories, twist facts and give only one side of the story, ignoring the other, and if this situation persists, newspapers will slowly but surely lose public sympathy, support, and without that sympathy and support, no constitution, no law, or no court can serve the purpose or serve the cause of press freedom. That is why a mechanism of self-regulation of the press is considered to be the most suitable. So, the Press Council of India. During the British rule in India, press freedom was one of the cherished goals of the freedom fighters in India, and after independence, when the Constitution of India was being written, the country was being partitioned and there was large-scale communal violence in the country as well as in the newly created country in the neighborhood. Thousands of refugees were coming into India from Pakistan, and in 1948 there was a war with Pakistan over Kashmir in Kashmir. Due to the shadow of tremendous political upheavals, the framers of the Indian Constitution did not pay sufficient attention to the issue of press freedom. They wanted to introduce the apparatus of controls wielded by the British into the constitutional structure of India. The Indian Constitution guarantees the fundamental right of freedom of speech and expression to every citizen of India as per Article 19(1)(a) of the Constitution, subject to certain reasonable restrictions specified in the Article 19(2). The High Courts and the Supreme Court are empowered to interpret these articles and declare the law whenever a case comes to them. There is no specific right of the freedom of the press, and the freedom of expression includes such a freedom. The Supreme Court, incidentally, does not see the right of the press going beyond the rights of the ordinary citizen. Just after the enforcement of the Constitution on January 26, 1950, the government felt the need to put more restrictions on the press than were enumerated in Articles 19(1) and (2). Because the Supreme Court and the High Courts had overruled the executive in a number of cases where newspapers had been penalized for publishing certain matters which offended the government. The court's view was that the Constitution of India had, in Article 19(2), expressly defined the limitations which might be imposed on freedom of expression. According to the courts, these limitations were for preventing libel, slander, defamation, contempt of court, or offences against decency or morality, or offences undermining the security of the state or tending to overthrow the state. The government then introduced the Constitution First Amendment Bill in 1950. One of the objectives of this bill was to add new grounds to the Article 19(2) for imposing restrictions on the press. There were strong protests against the bill, both from the press and from leading public figures. In order to pacify the press, the then Home Minister C. Rajagopalachari offered to refer all questions affecting the freedom of the press to a jury panel composed of editors. During the debate in Parliament, some members of Parliament expressed concern over the entry of big industrialists into the newspaper business. The then Prime Minister, Jawaharlal Nehru, said that the government was prepared to appoint a committee or commission, including representatives of the press, to examine the state of the press in India. On 1st June 1951, Nehru indicated that an inquiry covering larger issues of the press, such as had been carried out in the UK by the Royal Commission, might be productive for the development of the press in India as well. However, these assurances failed to calm the opposition to the proposed bill, and the government proceeded with the bill, which was passed by the House by 288 votes to 20. Journalists' organizations made strong protests and adopted a number of resolutions against the bill. They demanded assurances from candidates in the general elections they should work for its repeal. It was also decided that on 12th July 1951, as a protest, no newspaper would be published all over the country. However, the protests could not be carried out fully across India, perhaps because some newspapers were not willing to antagonize the government. The bill finally received the assent of the President of India as the Constitution First Amendment Act of 1951. Later, in the same year, the government introduced the Press Incitement to Crime Bill. The bill was passed with only some minor concessions, and the legislation was later known as the Press Objectionable Matters Act 1952. in this statute, there were provisions for demanding security from newspapers for their good conduct. The Indian Federation of Working Journalists, which came into existence on 29th October 1950 and soon became the largest journalists' organizations in India, at its session held in Calcutta in April 1952, formally demanded the appointment of a press commission to make a comprehensive inquiry into the entire working of the press in India. The demand was considered by the government, and in May the same year, the President of India, while delivering his address to the Parliament, announced that the government hoped to appoint in the near future a commission to consider various matters connected with the press. In subsequent months, there were constant charges against the industrialist, capitalist-owned newspapers regarding misuse of their columns for the promotion of their personal commercial interests. A public outcry against such practices, plus the government's antipathy towards a press owned by business houses, prompted the Nehru government in 1952 to finally institute a commission to inquire into the state of the Indian press, and thus the appointment of the first Press Commission of India was announced on 23rd September 1952, headed by Justice G.S. Rajyadhyaksh as chairman, and journalists' organizations having their representatives as its members. The commission had powers to make a searching inquiry and had wide terms of reference. According to a government communique of that time, the commission was supposed to examine the following. Number 1, the control, management and ownership and financial structure of newspapers, large and small periodicals, news agencies and feature syndicates. Number 2, the working of monopolies and chains of business and their effect on the presentation of accurate news and fair views. Number 3, the effect of holding companies, the distribution of advertisements and such other forms of external influence as may have a bearing on the development of healthy journalism. Next, the method of recruitment, training, scales of remuneration, benefits and other conditions of employment of working journalists, settlement of disputes affecting them, and factors which influence the establishment and maintenance of high professional standards. Next, the adequacy of newsprint supplies and their distribution among all classes of newspapers, and the possibilities of promoting indigenous manufacture of newsprint and printing and composing machinery as well. Next, mechanisms for ensuring high standards of journalism and liaison between the government and the press, and lastly, the issue of freedom of the press and the repeal or amendment of laws not in consonance with the theme of freedom of the press. The Press Commission was asked to make recommendations on all these matters and to submit its report by 1st March 1953, that was only 5 months since its constitution, to complete its work. However, the Commission secured an extension of time until the end of July 1954. The main recommendation of the first Press Commission was that a statutory Press Council of India should be established in the country. The Commission's report was in 3 parts, running into more than 1,700 pages. One part of the report included the history of Indian journalism. The Commission then enumerated the objectives of the proposed press council. Three of the objectives were quite similar to those listed by the Royal Commission for establishing the British Press Council, so much so that the language used by the Indian Press Commission was the same as it was in the British Press Commission's report. After referring to the Voluntary Press Council of the UK, the Press Commission of India gave the following reasons for preferring a statutory press council in India rather than a voluntary one. First, the British Press Council was facing problems in its functioning because of its voluntary character. Second, it was claimed that without statutory protection, the members of the Press Council as well as the Press Council itself might be threatened with legal action at every step of its activity. And third, a voluntary body would have no legal authority to make inquiries as and when the need arose. The history of the Press Council of India shows that many times since its inception, it has been the subject of legal actions. When the council was formed for the first time, its composition itself was challenged in a court of law. Perhaps due to its statutory character, the council could be easily drawn into legal battles. After 2 years of the recommendations made by the Commission, a bill for setting up a press council was introduced in the Rajya Sabha in 1956. The bill provided for the appointment of the chairman of the press council by the President of India, while the Press Commission of India had recommended the appointment of the press council's chairman by the Chief Justice of the Supreme Court. The bill also provided for the financing of the council by the government. The Commission had suggested that a fee should be charged to newspapers on the basis of newsprint consumed by them, and the proposed council should be financed by that fees. So, the bill was intended to make the Press Council a government office. It was passed by the Rajya Sabha but lapsed due to the dissolution of the Lok Sabha in April 1957. The first Press Commission, in its report in 1954, had actually recommended that the Press Council should be statutory, and Nehru had evinced sufficient interest in this particular recommendation. So, the Statutory Council was actually established after Nehru died. So, when the first Press Council of India Act 1965 was enacted, its chairman was J.R. Mudholkar, a sitting judge of the Supreme Court. Incidentally, the Press Council of India Act was repealed in 1975 during the imposition of internal emergency, and a fresh bill was framed in 1978 after the end of the emergency. But both the bills did not contain any provision for the post of vice chairman in the Press Council. So, the 1978 statute is still continuing, and the Press Council of India has a chairman, members, but no vice chairman. During the emergency in 1975, newspapers were the major target of the government of the then Prime Minister Indira Gandhi. Censorship was imposed on the news media. Fundamental rights of citizens guaranteed by the Constitution were drastically curtailed. During this period, on 8th December 1975, an ordinance was passed by the President of India which stated that the Press Council was to be abolished on the expiry of its term on 31st December 1975, and later in February 1976, the Press Council Act was repealed. The objectives and reasons appended to the Press Council Repeal Act of 1976 stated that the council was being abolished because it was not able to carry on its functions effectively to achieve the objects for which the Council had been established. Had the Press Council not been a statutory body and not funded by the government, it would not have abandoned its role so easily in the emergency days, at a time when it was needed actually to preserve press freedom. In fact, during the emergency, government advertising was banned in those newspapers who resolutely resisted government pressures. So, when the internal emergency ended in 1977 and Indira Gandhi lost power in the general elections that followed, the new government, headed by the Prime Minister Morarji Desai, introduced fresh legislation for establishing a press council, and the draconian law, the Prevention of Publication of Objectionable Matter Act, was also revoked. A former judge of the Supreme Court, Justice A. N. Grover, was appointed as chairman of the reconstituted Press Council on 3rd April 1977. The salient features of the Press Council of India are as follows. It is empowered to take up complaints against individual journalists, including freelance journalists. It can also take up complaints regarding advertisements. It is required not only to maintain high standards of journalistic ethics, but also to keep under review any development likely to create impediments to the free functioning of the press. It takes up most of the complaints against newspapers and or its editors with a view to maintaining standards of journalistic ethics. It also adjudicates complaints against the government in order to fulfill its obligations given in the latter part of the above objective. The Press Council may warn, admonish or censure a newspaper or a journalist or editor. On the other hand, in the case of complaints against the government, the Council is allowed only to make observations against an authority of the government. It makes it obligatory upon complaints to be written first to the editor of the newspaper or the news agency journalist against whom the complaint is meant to be lodged. No complaint is generally accepted by the Press Council of India unless the complainant certifies that he has brought the matter to the notice of the person against whom the complaint is being lodged and that he has failed to get redress from him. The complaint to the Press Council of India should be accompanied by the newspaper clipping containing the so-called offending passage or news item. The Press Council does not adopt a legal waiver system. This means a complainant can go to a court of law after getting his complaint adjudicated by the Press Council. The chairman of the Press Council of India can reject a frivolous complaint at the initial stage itself. If a complaint is not filed in the prescribed manner, the chairman might return the complaint, giving the complainant another opportunity to file it within the specified period after complying with the requirements of its regulations. If an editor does not file his preliminary comments on the complaint against his paper, the Press Council can proceed without waiting for such comments. The Press Council of India issues directions to the offending paper to publish its adjudication or the viewpoint of the complainant, but if a newspaper fails to comply with the directive, the Council has no further powers against that paper. The Council has no monitoring system for ensuring that its directions to erring newspapers are duly implemented by them within a reasonable time. A few points about the procedure for filing the complaint to the Press Council. should be mentioned here. While the Press Council of India accepts complaints by email, they need to be followed up by signed complaints as well. The complaints entertained by the Press Council are of two general natures. Number one, complaints against the press, and number two, complaints regarding oppression of press freedom. The first category is complaints against the press. This category is open to any person to lodge a complaint with the Press Council against a newspaper for a breach of recognized ethical canons of journalistic propriety and taste. The complainant, incidentally, need not necessarily be the person aggrieved or directly involved. The alleged breach may be in the publication or non-publication of a news item or a statement or other material like cartoons, pictures, photographs, strips or advertisements which are published in a newspaper. Cases can also be initiated by any member of the public against any professional misconduct by an editor, working journalist, staff of a newspaper, or someone who is engaged in freelance journalism work. There can also be a complaint against any matter transmitted by a news agency by any means whatsoever. By virtue of the Press Council Procedure for Inquiry Regulations 1979, the complaint shall be lodged with the Council within the following periods: for dailies, news agencies and weeklies within 2 months of the so-called offending passage being published, and in all other cases within 4 months, provided that a relevant publication of an earlier date may be referred to in the complaint. It is a requirement of the inquiry regulations that the complainant should initially write to the editor of the newspaper, drawing his attention to what the complainant considers being a breach of journalistic ethics or an offense against public taste. Such prior reference to the editor affords him an opportunity to deal with the matter in the first instance, and thus allows the respondent to take such remedial action as he might consider appropriate before the complaint is lodged with the Press Council. This rule is considered to be necessary because it acquaints the editor with the identity of his accuser and details of the complaint. It is conceivable that in some instance the complainant has been wrongly informed or has misinterpreted the facts. It may be a case of inadvertent error which the editor is only too ready to admit and correct. If the would-be complainant is satisfied, that would be the end of the matter, and further action may not be required. Where, after reference to the newspaper, the person desires to proceed with the complaint, he should enclose with his complaint the copies of correspondence with the editor. If no reply has been received from the editor, the fact should be mentioned in the complaint. The complainant has in his complaint to give the name and address of the newspaper, the editor or journalist against whom the complaint is directed, a clipping of the matter or news item complained of in original or self-attested copy, and English translation if the news item is in vernacular must accompany the complaint. The complainant has to state in what manner the passage or the news items or the material complained of is considered to be objectionable. He should also supply any other relevant particulars that may be considered necessary to support his complaint. In the case of a complaint against non-publication of material, the complainant will of course say how that constitutes a breach of journalistic ethics. The Council, incidentally, cannot deal with any matter which is sub judice in the law court. The complainant has to declare that, to the best of his knowledge and belief, he has placed all the relevant facts before the Council, and that no proceedings are pending in any court of law in respect of any matter alleged in the complaint. A declaration that he shall notify the Council forthwith if during the pendency of the inquiry before the Council any matter alleged in the complaint becomes the subject matter of any proceedings in a court of law is also made necessary. The second category is of complaints regarding oppression of press freedom. A newspaper, a journalist, or any other institution or individual can complain against the central government or the state governments or any organization or any person for interfering with the free functioning of the press or encroachment on the freedom of the press. Such complaints should contain full particulars of the alleged infringement, whereupon the Press Council shall follow the procedure of inquiry set out above, as the case may be. The opinion expressed by the Council serves two useful purposes. Number one, that any abuse of press freedom does not pass without anybody noticing it or raising a finger of protest, and two, that the press should not, in its own interest, indulge in scurrilous or other objectionable writings such as have been considered below the level of recognized standards of journalistic ethics by a fair-minded jury like the Council constituted of the press itself, for it would lead to the very loss of the much prized freedom of the press. It is a requirement of the inquiry regulations that the complainant should draw the attention of the respondents or the authorities towards the grievances, say how the action or inaction of the respondent authorities amounts to curtailment of the freedom of the press, mention the possible reason for the action or inaction of the respondents or authorities duly supported by a documentary evidence, and furnish a copy of the letter written to the respondents or authorities. In case the action of the respondents or authorities is a reprisal measure for writings in the newspaper critical of the respondents, the cuttings of such reports must be furnished in original or as self-attested copies, and naturally with an English translation if the original is in vernacular. So, this is in brief everything that those wishing to enter the profession must know about the Press Council, how it was constituted, how it functions, what kind of complaints it can look into, and what kind of action or suggestions it can make. Now we move to the other important aspect related to the freedom and ethics of the media, that is, the laws concerning the press. In societies which followed communism and totalitarianism, like the former USSR and China, there were limitations of what the media could say about the government. Almost everything that was said against the state was censored for the fear of any possible revolution among the public. On the other hand, in countries with liberal democracy like the USA, almost everything was and is allowed in the media to be written or spoken out. In the Indian perspective and within its system of parliamentary democracy, the press is free but subject to certain restrictions imposed by the Constitution of India as mentioned earlier. Before the impact of globalization was felt, the mass media was more tightly in control of the government, but now the situation has changed. When we say the media, we include productions in the area of print, radio, video, films, web, and also the global information systems. Whereas it is advisable to impose certain legal checks and bounds on transmission and communication, there is also the need to have checks in place so that the genuine freedom of the press is not curtailed. Let's have a look at the historical perspective of laws concerning the media. Mass media laws in India have a long history and they are deeply rooted in the country's colonial experience under British rule. The earliest regulatory measures can be traced back to 1799 when Lord Wellesley promulgated the press regulations. These regulations had the effect of imposing pre-censorship on the nascent newspaper publishing industry in India under British rule. In 1835, the Press Act was promulgated, which undid most of the repressive features of earlier legislations on the subject. On 18th June 1857, the government passed a regulating act which, among various other things, introduced compulsory licensing for the owning or running of printing presses, empowered the government to prohibit the publication or circulation of any newspaper, book, or other printed material, and banned the publication or dissemination of statements or news stories which had a tendency to cause a furor against the government of the day, thereby weakening its authority. Then followed the Press and Registration of Books Act in 1867. This act incidentally continues to remain in force till the present date. Governor General Lord Lytton promulgated the Vernacular Press Act of 1878, allowing the government of the day to clamp down on the publication of writings deemed seditious and to impose punitive sanctions on printers and publishers who failed to fall in line. In 1908, Lord Minto promulgated the Newspapers Incitement to Offences Act 1908, which authorized local authorities to take action against the editor of any newspaper that published matter deemed to constitute an incitement to rebellion. We can see here that all the laws promulgated during the British rule in India by the British government were intended to curb the voice against the British rule and the voice which was generally coming from those who were votaries of independence of India. When the Constitution of India was brought into force in January 1950, the freedom of the press as a theme was actually incorporated in the statute to empower the press to disseminate knowledge to the masses, and the Constituent Assembly therefore decided to safeguard this freedom of the press as a fundamental right. Although the Indian Constitution does not expressly mention the liberty of the press, it is evident that the liberty of the press is included in the freedom of the speech and expression under Article 19(1)(a). It is, however, pertinent to mention that such freedom is not absolute but is qualified by certain clearly defined limitations under Article 19(2) in the interests of the public, as has been mentioned earlier. It is necessary to mention here that this freedom under Article 19(1)(a) is not only confined to newspapers and periodicals, but also includes publications like pamphlets, leaflets, handbills, circulars, and every sort of publication which affords a vehicle of information and dissemination of opinion among the masses. Thus, although the freedom of the press is guaranteed as a fundamental right, it is necessary for us to deal with the various laws governing the different areas of the media so as to appreciate the vast expanse of media laws in the country, the various acts which have to be taken into consideration when dealing with the regulations imposed upon the print media deal with not only the newspaper content but the working of the media organizations and other things related to the people working in the industry, as well as the methods enforced and applied by the media industry itself. So, the laws are as mentioned here. The Press and the Registration of Books Act 1867. This act regulates printing presses and newspapers and makes registration with an appointed authority compulsory for all printing presses. The other act is the Press Objectionable Matters Act 1951. This enactment provides against the printing and publication of incitement to crime and other objectionable matters. The Newspapers Prices and Pages Act 1956. This statute empowers the central government to regulate the price of newspapers in relation to the number of pages and size, and also to regulate the allocation of space to be allowed for advertising matter. When dealing with this law, it will be worthwhile to mention about a particular case of Sakal Papers Limited versus the Union of India. In this case, the daily newspaper's Price and Control Order 1960, which fixed a minimum price and number of pages which a newspaper is entitled to publish, was challenged as unconstitutional. The state justified the law as a reasonable restriction on a business activity of a citizen, but the Supreme Court struck down the order, rejecting the state's argument. The court opined that the right of freedom of speech and expression could not be taken away with the object of placing restrictions on the business activity of the citizens. Freedom of the speech, the apex court ruled, could be restricted only on the grounds mentioned in the clause 2 of Article 19. Then there is the Defence of India Act 1962. This act came into force during the emergency proclaimed in 1962, followed by the external aggression. This act aimed at restricting the freedom of the press to a large extent, keeping in mind the unrest prevailing in India in lieu of the war against China. The act empowered the central government to issue rules with regard to prohibition of publication or communication considered prejudicial to the civil defense or military operations, prevention of prejudicial reports, and prohibition of printing or publishing any matter in any newspapers that was considered dangerous to the defense of India. Another act is the Delivery of Books and Newspapers Public Libraries Act 1954. According to this act, the publishers of books and newspapers are required to deliver free of cost a copy of every published book to the National Library at Calcutta and one copy each to the 3 other public libraries specified by the central government. Then there is the Working Journalists and Other Newspaper Employees Conditions of Service and Miscellaneous Provisions Act 1955. This act lays down the minimum standards of service conditions for newspaper employees and journalists. This act has been instrumental in laying down some structural conditions for employees of newspapers in later years. The Civil Defense Act 1968. This act allows the government to make rules for the prohibition of printing and publication of any book, newspaper, or other document prejudicial to civil defense. Although the Constitution on one hand confers the fundamental right of freedom of the press, the Article 105(2) provides certain restrictions on the publications of the proceedings of Parliament. In the famous Searchlight case, the Supreme Court held that the publication by a newspaper of certain parts of the speech of members in the House which were ordered to be expunged by the Speaker constituted a breach of privilege. Among the other laws, 2 are very important as far as the working of the press is concerned. These are the Contempt of Courts Act 1971, the Parliamentary Proceedings Protection of Publication Act, and the Official Secrets Act of 1923. The Contempt of Courts Act 1971. Contempt of court means civil contempt or criminal contempt, and while civil contempt means willful disobedience to any judgment, decree, direction, order, writ, or other process of a court, or willful breach of an undertaking given to a court. Criminal contempt means the publication, whether by words spoken or written, or by signs, or by visible representations or otherwise, of any matter or the doing of any other act whatsoever which scandalizes, lowers, prejudices, or interferes with the due course of any judicial proceeding or the administration of justice in any other matter. It must be remembered here that innocent publication and distribution of any matter is not considered contempt of court. A person, the Act says, shall not be deemed guilty of contempt of court on the ground that he has published any matter which interferes with the course of justice in connection with any civil or criminal proceeding pending at the time of publication, if at the time he had no reasonable grounds for believing that the proceeding was actually pending. A person shall not be guilty of contempt of court on the ground that he has distributed a publication containing any such matter if at the time of distribution he had no reasonable grounds for believing that it contained or was likely to contain any such matter as aforesaid. This subsection shall not apply in respect of the distribution of any publication which is a book or paper printed or published otherwise than in conformity with the rules contained in Section 3 of the Press and Registration of Books Act 1867. It also lays down that fair and accurate report of judicial proceedings is not contempt. Fair criticism of any judicial act is also not contempt if it constitutes any fair comment on the merits of any case which has been heard and finally decided. It also mentions that publication of information relating to proceedings in chambers or in camera is not contempt except in certain cases. It must be mentioned here that the Contempt of Courts Act is one of those laws which is considered to be very stringent, and every journalist who is reporting on court cases or who is reporting on the daily proceedings of a court case is always a little scared of this act, because every judge of the court is empowered to take suo motu notice of reports appearing in the newspapers about the court's proceedings. In fact, in certain high profile cases of crime, fraud, or of political nature, the judges have had issued specific instructions that the proceedings should not be reported or should be reported as directed, otherwise the provisions of the Contempt of Court Act may be applied. So, in most newspapers and TV news channels, there are lawyers who are appointed to actually oversee and approve the proceedings of the court cases. Therefore, it is not very easy for newspapers to go in for actual proceedings as such. The actual proceedings of the court cases are first showed to a lawyer or to a law reporter, who may pick up what sentences can be freely reproduced or reported and what portions of the court proceedings need to be held back. Then there is the Parliamentary Proceedings Protection of Publication Act 1977. In order to strengthen the basis of democratic government, which is the Parliament and an opinion of the people, it is of paramount importance that the proceedings in Parliament shall be communicated to the public. For this purpose, newspapers and other mass publicity media should be afforded the privilege of publishing substantially true reports of proceedings in Parliament without being exposed to any civil or criminal action. Under this Act, no person shall be liable to any proceedings, civil or criminal, in any court in respect of the publication in newspaper of a substantially true report of any proceedings of either House of Parliament, unless the publication is proved to have been made with malice or malicious intent. The Act is supposed to apply in relation to reports or matters broadcast by means of a wireless telegraphy as part of any program or service provided by means of a broadcasting station situated within the territories to which this Act extends, as it applies in relation to reports or matters published in a newspaper. It must be noted here that the provisions of the Parliamentary Proceedings Act also apply in coverage of the assembly proceedings in all states. Here also, the journalists or reporters covering the assembly or parliament proceedings are supposed to be very cautious about what part of the proceedings in the House is to be reported and what part is to be omitted. Here also, the Speaker of the House, whether it is the Lok Sabha or the Vidhan Sabha in the states, can take notice of whatever appears the next day and haul up the publication or the journalist for having committed a contempt if the publication of that particular report is considered to be contemptuous. In most cases, Therefore, the proceedings of the Parliament, the Houses of Parliament and the Assembly are cleared by a panel of senior editors, including experts on parliamentary proceedings, so that the provisions of Contempt of Parliamentary Proceedings Act are not applied on newspapers. Then we come to the Official Secrets Act 1923. This act, enacted on April 2, 1923, is a fairly wide and comprehensive piece of legislation which, if enforced as per letter and spirit, could make every publishing activity guilty of some offense or the other. It covers a wide range of activities as being detrimental to the safety and security of India. These include being in the vicinity of government offices or security camps, being found in possession of documents or items, impersonation and harboring a spy besides others. The items which are covered include any communication, photograph, sketch, plan, model, article, note, document, piece of information, substance, effect or description, their possession or copying, munitions of war including the whole or any part of any ship, submarine, aircraft, tank or similar engine, arms and ammunition, torpedo or mine intended or adapted for use in the war, and any other article, material or device, whether actual or proposed, intended for such use. If any person for any purpose prejudicial to the safety or interests of the state approaches, inspects, passes over or is found or caught in the vicinity of or enters any prohibited place or makes any sketch or is found in possession of or communicates to any other person any secret official code which is calculated to be or might be or is intended to be useful to an enemy shall be punishable with imprisonment for a term ranging from 3 years to 14 years, depending upon the importance of the place or document in question. As is evident from this very brief description of the Official Secrets Act, it gives wide powers to the enforcing agencies to book anyone who they think is acting suspiciously or may cause harm to the security establishment. Demands for its abolition or amendment have been made from several quarters over the years. If used with malicious intent, every act of news gathering could be termed as an offense under this act. In fact, entering certain government offices, being seen with a camera or a notepad around such offices, talking to people who are working on sensitive positions in certain offices, or trying to copy or note down notings from documents in certain offices are also covered as being offense under the Official Secrets Act. One can imagine that for a journalist who is covering, say, the Defense Ministry or certain other offices for the purpose of journalistic work or reporting on events related to such departments, is always open to being caught or questioned, detained or even prosecuted under the Official Secrets Act. The fact remains that every journalist who covers such sensitive areas such as civil aviation or defense or police or military and so on is always under constant danger of being booked under this act, and it is only because of the prevailing feeling and philosophy of freedom of the press that such action is generally not taken after it is ensured that the journalist was merely doing his duty. But the fact remains that the act, if used to its letter and spirit, and if used with malicious intent, can prohibit every act of news gathering activity and also being seen close to or near an office of sensitive nature as being an offense, and therefore reporting about the proceedings or working of such offices would never be possible. With this, we come to the end of this lecture. As we have seen, the subject of monitoring the activities of the press has always commanded great attention of the government before and after independence. Independent India saw the establishment of a Press Council of India for looking into specific complaints or grievances against the media, while the laws concerning the media give wide powers to the enforcement agencies. Besides, there are many laws that control various aspects of the media houses as well. For example, there are laws that control the use of electricity, telecom lines, working conditions of employees, their wages, their disputes, and so on, that are covered by various laws of the land. So, in the next and concluding discussion on the subject, we will look into the laws concerning the audiovisual media and some new situations that have arisen before the media as far as the ethics are concerned. My best wishes till then, and thank you.